Broadcast is now starting. All attendees are in listen-only mode.
Good morning, everyone, and thank you for joining us today. My name is Jeffrey Salant. I am the new HOA Information Officer for the Division of Real Estate, which is a division of the Colorado Department of Regulatory Agencies, also known as DORA. This morning we're going to talk about association records in HOAs and what the requirements are for an HOA regarding the maintaining and producing of those records, as well as the rights of the HOA homeowners in getting access to and obtaining those records. Please note that the information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. This slide shows you the division's HOA Information and Resource Center website, where you can find information and resources concerning board member education, educational guidance on buying a home in an HOA, HOA-related state and federal laws, reports and educational publications, helpful links for association members, board member FAQs, registering an HOA, filing a complaint against an HOA, and registering for an HOA forum. You may find it at www.colorado.gov/pacific/Dora/information-and-resource-center. This next slide displays a newly created section of the website for the HOA Center and contains 16 board member education videos that can assist board members and homeowners understand their roles, rights, and responsibilities related to overseeing and living in an HOA. Please visit this new website page for some great information. It will be the first link under the HOA Information and Resources section on the web page in our previous slide. In this section of the Colorado Common Interest Ownership Act, also known as CCIOA or Kiowa, we will be discussing the association's obligations regarding maintaining records, the types of records to be kept, disclosure of documents to owners, records to be withheld, and timing and costs for providing records. A full section of the Kiowa law is devoted to the association's records and is located in Section 38-33.3-317. In addition to any records specifically defined in the association's declaration or bylaws, or expressly required by the Kiowa, the association must maintain certain records, all of which must be deemed to be the sole records of the association for purposes of document retention and production to owners. These records consist of detailed records of receipts and expenditures affecting the operation and administration of the association, records of claims for construction defects and amounts received pursuant to settlement of those claims, minutes of all meetings of its unit owners and executive board, a record of all actions taken by the unit owners or executive board without a meeting, and a record of all actions taken by any committee of the executive board. Written communications among and the votes cast by executive board members that are 1. Directly related to an action taken by the board without a meeting, or 2. Directly related to an action taken by the board without a meeting pursuant to the association's bylaws. Also included in this section is the names of unit owners in a form that permits preparation of a list of the names of all unit owners and the physical mailing addresses at which the association communicates with them, showing the number of votes each unit member is entitled to vote, except that this requirement does not apply to a unit or the owner thereof if the unit is a timeshare unit. Also included is its current declaration, covenants, bylaws, articles of incorporation, if it is a corporation, or the corresponding organizational documents if it is another form of entity, rules and regulations, responsible governance policies adopted pursuant to the Kiowa, and other policies adopted by the Executive Board. Financial statements for the past 3 years, and tax returns of the association for the past 7 years to the extent available. A list of names, electronic mail addresses, and physical mailing addresses of its current executive board and officers. Also included is the association's most recent annual report delivered to the Secretary of State, if any, financial records sufficiently detailed to enable the association to comply with the Kiowa concerning statements of unpaid assessments, the association's most recent reserve study, if any, current contracts to which the association is a party, and contracts for work performed for the association within the immediately preceding 2 years. Also included is records of executive board or committee actions to approve or deny any requests for design or architectural approval from unit owners. Ballots, proxies, and other records related to voting by unit owners for 1 year after the election, action, or vote to which they relate. Also included in this section are any resolutions adopted by its board of directors relating to the characteristics, qualifications, rights, limitations, and obligations of members or any class or category of members. All written communications within the last 3 years to all unit owners generally as unit owners. In addition, with regard to examination and copying of records by a homeowner, subject to other sections of the Kiowa law, all records maintained by the association must be available for examination and copying by a unit owner or the unit owner's authorized agent. The association may require unit owners to submit a written request describing with reasonable particularity the records sought at least 10 days prior to inspection or production of the documents, and may limit examination and copying times to normal business hours or the next regularly scheduled executive board meeting if the board meeting occurs within 30 days after the request. Notwithstanding any provision by the declaration, bylaws, articles, or rules and regulations of the association to the contrary, the association may not condition the production of records upon the statement of a proper purpose. With regard to an association membership list, a membership list or any part thereof may not be obtained or used by any person for any purpose unrelated to a unit owner's interest as a unit owner without consent of the executive board. Without consent of the executive board, a membership list or any part thereof may not be used to solicit money or property unless such money or property will be used solely to solicit the votes of the unit owners in an election to be held by the association, used for any commercial purpose, or sold to or purchased by any person. Regarding records that may be withheld from a homeowner at the discretion of the executive board, records maintained by an association may be withheld from inspection and copying to the extent that they are or concern architectural drawings, plans, and designs, unless released upon the written consent of the legal owner of the drawings, plans, or designs. Contracts, leases, bids, or records related to transactions to purchase or provide goods or services that are currently in or under negotiation. Communications with legal counsel that are otherwise protected by the attorney-client privilege or the attorney work product doctrine. Disclosure of information in violation of law. Records of an executive session of an executive board. Individual units other than those of the requesting owner, or the names and physical mailing addresses of unit owners if the unit is a timeshare unit. Regarding records that must be withheld from a homeowner, records maintained by an association that are not subject to inspection and copying and must be withheld to the extent that they concern or are personnel, salary, or medical records relating to specific individuals, or personal identification and account information of members and residents, including bank account information, telephone numbers, electronic mail addresses, driver's license numbers, and social security numbers. Except a member or resident may provide the association with a written prior consent to the disclosure of, and the association may publish to other members and residents, the person's telephone number, electronic mail address, or both. The written consent must be kept as a record of the association and remains valid until the person withdraws it by providing the association with a written notice of withdrawal of the consent. If a person withdraws his or her consent, the association is under no obligation to change, retrieve, or destroy any document or record published prior to the notice of withdrawal. Can the association charge for providing records to its homeowners? The association may impose a reasonable charge, which may be collected in advance and may cover the costs of labor and materials for copies of association records. The charge may not exceed the estimated cost of production and reproduction of the records. A right to copy records under this section includes the right to receive copies by photocopying or other means, including the receipt of copies through an electronic transmission, if available, upon request by the unit owner. An association is not obligated to compile or synthesize information. Association records and the information contained within those records must not be used for commercial purposes. Next, we will discuss the association records as they are considered corporate records. The Colorado Revised Nonprofit Corporation Act discusses the association's obligations regarding corporate records, inspection of corporate records by members, scope of the member's inspection right, court-ordered inspection of corporate records, limitations on the use of membership lists, and financial statements. A nonprofit corporation must keep as permanent records minutes of all meetings of its members and boards of directors, a record of all actions taken by the members or board of directors without a meeting, a record of all actions taken by a committee of the board of directors in place of the board of directors on behalf of the nonprofit corporation, and a record of all waivers of notices and of meetings of members and the board of directors or any committee of the board of directors. A nonprofit corporation must maintain appropriate counting records. It must maintain a record of its members. It must maintain its records in written form or in another form capable of conversion into written form within a reasonable time. It must keep a copy of each of the following records at its principal office location: its articles of incorporation, its bylaws, resolutions adopted by its board of directors relating to the characteristics, qualifications, rights, limitations, and obligations of members or any other class or category of members. The minutes of all members' meetings and records of all action taken by members without a meeting for the past 3 years. All written communications within the past 3 years to members generally as members. A list of the names and businesses or home addresses of its current directors and officers. A copy of its most recent periodic report. And all financial statements prepared for periods ending during the last 3 years that a member could have requested. A nonprofit HOA corporation has an obligation to allow its members, also known as homeowners, access and inspection of certain corporate records. Section 7-136-102, titled Inspection of Corporate Records by Members, lists that a member is entitled to inspect and copy during regular business hours at the nonprofit corporation's principal office any of the records of the nonprofit corporation if the member gives the nonprofit corporation written demand at least 5 days before the date on which the member wishes to inspect and copy such records. Furthermore, a homeowner has some additional rights of inspection. Under Section 7-136-103, Scope of a Member's Inspection Right, it lists that a member's agent or attorney has the same inspection and copying rights as the member. The right to copy records includes, if reasonable, the right to receive copies made by photographic, xerographic, electronic, or other means. The nonprofit HOA corporation may impose a reasonable charge covering the costs of labor and material for copies of any documents provided to the member. The charge may not exceed the estimated cost of production and reproduction of the records. If the corporation refuses to allow the homeowner access to inspect or copy the records that one is entitled to, a remedy exists pursuant to the Act. Under Section 7-136-104, titled Court-Ordered Inspection of Corporate Records, if a nonprofit corporation refuses to allow a member or the member's agent or attorney to inspect or copy any records that the member is entitled to inspect or copy, the district court for the county where the corporation is located can summarily order the inspection or copying of the records demanded at the nonprofit corporation's expense. The court can also order the nonprofit corporation to pay the member's costs, including reasonable counsel fees incurred to obtain the order. The court may also order the nonprofit corporation to pay the member for any damages the member incurred. The court may grant the member any other remedy provided by law. There are corporate restrictions under the Act for the use of the membership list. For example, Section 7-136-105, titled Limitations on the Use of Membership List, states that without the consent of the Board of Directors, a membership list or any part thereof may not be obtained or used by any person for any purpose unrelated to a member's interest as a member. Without limiting the generality of subsection 1 of this section, without the consent of the Board of Directors, a membership list or any part thereof may not be used to solicit money or property unless such money or property will be used solely to solicit the votes of the members in an election to be held by the nonprofit corporation. The list may not be used for any commercial purpose, and it may not be sold to or purchased by any person. Finally, the homeowner is entitled to the corporation's financial statements. Section 7-136-106, titled Financial Statements, states that upon the written request of any member, a nonprofit corporation must mail to such member its most recent annual financial statements, if any, and its most recently published financial statements, if any, showing in reasonable detail its assets and liabilities and results of its operations.